Where do you want the jury to sit?
We have the jury right there in front of the two timekeepers, and then the presiding judge up there.
Great, thank you.
Please, have a seat. All right, so Catherine, we have everybody, right?
Yeah, I think so.
Okay. So, I guess for the next hour or so, I'm Judge Rick Lukowitz. Welcome. Good luck to you all. Let's do attorney introductions first, please, and slowly with the last name, since I didn't get that and my ballot froze for a bit last time. So.
Good afternoon, Your Honor. My name is Ethan Marx, M-A-R-X, like Carl Groucho.
Okay.
I'm here with my co-counsel, Annabelle Claypool.
Good afternoon.
Good afternoon.
Together, we represent the plaintiff, the estate of Peter Jones.
Good morning, Your Honor. My name is Ria Debnath. That's D-E-B-N-A-T-H.
Okay.
I'm joined here today by my colleague, Mr. Luke Ryder.
Hi, Your Honor.
Hello.
And together we represent the studio, Dragon Studios, who's here in court today with Miss Cole Doyle. Good afternoon, Your Honor.
Good afternoon. All right. Are there any preliminary matters that we need to go through?
Just one from us, Your Honor. We just want to note for the record that pursuant to pretrial order 6, there have been a number of exhibits, quite a few actually, that have been pre-admitted before today's trial. Those are exhibits 1 through 25. We just wanted to ask your permission, given that they are pre-admitted, to use some of those exhibits during opening statements and throughout the course of trial.
Unless there's some objection I'm not aware of.
That's
Yeah,
fine with us, Your Honor.
Yeah, no, I think that's the whole point of pre-admission, but thank you for checking.
Perfect. There's nothing else from us.
Very well.
A couple of things from the defense, Your
Sure.
Honor. We move to invoke Rules 603 and 615 that constructively swear in and exclude all witnesses in the trial, barring party representatives. Ms. Doyle will be here representing the defendant in today's case.
And I believe that's a given, correct?
It is.
Okay.
In addition to that, Your Honor, as the defense, we've elected to pursue an affirmative defense while also disputing negligence in this trial. In this jurisdiction, it's procedure for us to make notice of that and also hand the judge the verdict form. Could I approach and tender?
Absolutely. Counsel's seen that.
We have no objections.
Hey, Your Honor.
Thank you.
With that, Your Honor, we've got nothing further. We're ready to go.
Very well. So let's go to opening statements.
Yes, Your Honor. The producer who pushed too far. Members of the jury, this is a negligence case. The victim is a 32-year-old man named Peter Jones. He was a father to 3 young girls. He was an actor right here in LA. Today you're going to learn that on June of 2023, Mr. Jones died while performing a stunt that he had practiced countless times before. Here's how it worked. Mr. Jones would ride on a motorcycle off a ramp and jump off. Then he would wait for a signal, letting him know when to release the parachute. After that signal, he would float to the ground and land safely. But today you're going to learn that on the day they filmed that movie, on the day Mr. Jones died, his producer pushed him to do that stunt differently. You'll learn that every other time Mr. Jones had done that stunt in the past, he had worn this earpiece. That's how he would get the signal to know when to release the parachute. But you're going to learn that on the day Mr. Jones died, as he got lower and lower and lower towards the ground, that signal, it never came. Instead, you'll learn that the producer, the person on the other end of the line, stayed silent. Today we're going to prove that that producer didn't stay silent to keep her clients safe. We'll prove that she did it because she dangerously disregarded the risks of that stunt. That's why we brought a claim of negligence against the defendant today, a studio owned by that producer. And because we brought that claim, we took on a burden. That means we have to prove to you by a preponderance of the evidence, or that it's more likely than not, that the defendant breached their duty to Mr. Jones. And that breach, that their failure to act responsibly, was the cause of his death. But today the judge is going to tell you that we're not the only ones with a burden. You're going to hear that today the defense has brought something called an affirmative defense of assumption of risk. That means that they've taken on a burden to prove that it's more likely than not that Mr. Jones understood the risks of performing that stunt, understood the gravity of those risks, and decided to do it anyways. But today they're not going to be able to meet that burden. Because today we're going to show that the producer violated the agreement that they had. You're going to see that it was the producer who pushed too far. And to help you see that, we're going to ask you to keep three things in mind as you listen to the evidence today: the stunt, the signal, and the silence. So first, the stunt. You're going to hear that Mr. Jones had practiced that stunt countless times before. You'll hear that on the day before he died, he performed that stunt 6 times in a row perfectly. But we're going to call his agent to the stand. She's going to tell you that she was there that day, and that after he performed that stunt 6 different times, his producer pushed him to do another take. That's going to bring us to that second thing, the signal. You'll hear that every time Mr. Jones had done that stunt before, he got that signal in that earbud we showed you a few moments ago. But you're going to hear that on the day he died, his producer pushed him to wait longer than he had ever waited for to deploy that parachute. You're going to see that that gave him less time to make it safely back to the ground. So finally, we'll talk about the silence. You'll hear that as Mr. Jones got lower and lower to the ground, the producer waited. 5, 10, 15 seconds, the producer stayed silent. You'll hear that Mr. Jones, he was scared, he was struggling, he grabbed at that parachute, tried to open it, but he was too late. You'll hear that he dropped thousands of feet, hit the ground at a speed of 120 miles per hour, and died instantly. And today we'll show you why. We'll show you that it was the producer who pushed too far. Pushed Mr. Jones to do that different stunt. Pushed Mr. Jones to wait longer to deploy his parachute, and pushed him to his death. It's why we'll ask at the end of this trial that you find the defendant liable. Thank you.
Thank you, counsel. Ms. Debnath?
Yes, Your Honor.
Did I pronounce that right?
Absolutely.
Okay. Go right ahead.
Yes, Your Honor. I'm going to budge this witness chair just a bit so I will read it.
Sure.
May I proceed, Your Honor?
Please.
He took the risk to protect his reputation. Members of the jury, there's a moment from the day before Mr. Jones died that the plaintiff, they left that other story. It's June 20th of 2021. And Mr. Jones, he's at a producer's dinner. Now he learns that the stunt shots they've gotten there too short, they're not daring enough. So he's got two options. One, he can take a longer fall, make the stunt more dangerous. Or two, he's not the legend he thought he was. And they've got to edit together the scenes to make it seem like that stunt was daring. He picks option number one. He chooses to take a risk to protect his reputation. See, members of the jury, the plaintiff, they got up here just now and told you that the producer pushed too far. That's not quite how it went down. The producer didn't push too far. The producer proposed a plan. And the actor, they agreed. Now, members of the jury, I understand it's difficult to think that someone could be responsible for their own death, especially in a case as brutal as this. But here, in this courtroom, the law demands that we consider exactly that possibility. Now, for this case, the law, it comes in two parts. First, we have the plaintiff's burden of proof. Proof by a preponderance of the evidence, more likely than not. So for this trial, as we're listening to the evidence, I want us to think of it this way. Imagine I'm splitting the courtroom in half, right down the center. And just to the right of this line, on the plaintiff's side, well, that's where they met their burden. Members of the jury, if that's where they meet their burden, the plaintiff, they start all the way over here with the defense. No facts, no evidence in their favor. It's their job to push the weight of the evidence forward, inch by inch, piece by piece, until they've convinced you that they've not only met this line, but they've surpassed it. And in this case in particular, members of the jury, that's important. Because the plaintiff, they got up here and they made a pretty bold claim. That Ms. Doy, Mr. Jones's production manager, that she failed to make that call, that parachute signal that was supposed to save Mr. Jones's life. And here's the thing, members of the jury, they can't just tell you that. That line, that burden means they have to prove it up with evidence. And that is not a burden they will be able to meet. But even if you do think that at some point the production company did commit some act of negligence, even then, members of the jury, there's another hurdle that they have to cross. Because the defense, we're bringing our own affirmative defense. We're going to show you today that it's more likely than not that Mr. Jones knew the risks of that stunt. And he chose to do it anyway. We're going to prove that to you with two simple facts. First, Mr. Jones knew the risks. And second, he took those risks for his reputation. So let's start with that first fact. How are we going to find out that Mr. Jones knew the risks? Well, members of the jury, you're going to see today that we've got it in writing. You're going to have a chance to take a look at this contract throughout the course of this trial, and we're going to find out that this contract and the stunt plan associated with it, it outlines every single risk that came with that stunt, including the risk of death. But beyond this contract, members of the jury, you're going to find out that Mr. Jones, he agreed to to an even more dangerous version of the stunt. A version of the stunt where he would fall for not 4 seconds, but 9 seconds. That it was his choice to take that risk. But at this point, you might be wondering, why? Why would anyone do this? Well, that's fact number 2. He took the risk for his reputation. See, members of the jury, here in court today, we're going to have a chance to speak to Mr. Jones's agent, someone who knew him well. She knew that Mr. Jones's reputation was important to him, that this sort of do anything for your audience reputation that he gained from doing his stunts, it was part of his brand. Now look, members of the jury, everyone in this courtroom will agree that what happened to Mr. Jones is a tragedy. But what we're here to decide is who is legally at fault. I trust that you'll let the evidence, not the emotions, guide your judgment. He took the risk to protect his reputation. At the end of this trial, I'll come before you again, and I'll ask that you find our client not lying. Thank you.
Thank you, counsel. Catherine, jurors, can all of you see the witness if he's or she is over here?
I think I should be able to, but let's maybe
Let's move
call-
it up a little bit.
Yeah. Thank you, that's perfect. Well, I don't want to block the defense representative, so we can also just maybe move the seat down.
Yeah, moving down would be helpful
Yeah.
too. Thank you, good idea. I assume both counsel are fine with that adjustment?
Yes, Your Honor.
No objection.
Okay. All right, first witness, plaintiff, actually, apparently, based on what I know from pretrial, only witness?
Yes, Your Honor. Plaintiff calls Ellie Gokian.
That's fine.
Good afternoon. Could you go ahead and introduce yourself to the members of the jury?
Good afternoon. My name is Ellie Goki.
Where are you from, ma'am?
I was born and raised right here in LA.
What do you do for a living?
I'm a talent agent, not to be confused with a travel agent. My grandma keeps telling everyone that I'm a travel agent, but I book jobs, not flights.
Ma'am, I want to talk about why we're here today. Do you know someone named Peter Jones?
I do. Peter was my client and my friend.
When was the last time you saw him?
June 21st, 2023. We were working on this stunt for his new movie, All Lost 7.
I want to talk a little bit more about that movie. Do you know who was producing it?
Yeah, it was produced by Dragon Studios and Miss Cole Doig.
Now, was Miss Doig on set while you were shooting that movie?
Yeah, she was. She was in the control room with me.
Ma'am, you told us that you were working on a stunt. Were you aware of the planning leading up to that stunt?
I was. As Peter's agent, I was involved in a lot of the meetings leading up to it and the contract meetings as well.
So could you describe an overview of the plan for that stunt to the members of the jury?
Of course. So the plan was for Peter to drive a motorcycle off a ramp, off of a mountain, to release the bike, free fall for a couple of seconds, and then pull his parachute.
Now, ma'am, you told us that that was the plan for that event. Could you explain a little bit what the plan was for Mr. Jones to know when to deploy that parachute?
Right, so me and Miss Doig were in the control room, and Peter had this earphone that he would wear where Miss Doig would give him a signal, and that's how he would know when to pull the parachute.
Would you recognize that earpiece if I showed it to you?
Yeah, I think I would.
I'm handing the witness what's been pre-admitted as Exhibit 4.
Thank you.
Ma'am, do you recognize what I just handed you?
Yeah, this looks like the earbud.
Now, ma'am, you told us that it was Ms. Doig who was going to be sending the signal to that earbud. Where was she planning to do that from?
From the control room. We had this footage where we could see what was happening with the stunt, and that's how she would be able to give the signal.
So, ma'am, we've walked through the plan for that stunt. I want to talk a little bit about the preparation.
Okay.
Do you know if Mr. Jones practiced for that stunt at all?
He did, of course. He practiced the jump and the skydiving multiple times.
And ma'am, when did filming begin on that stunt?
We started filming on June 20th, and we continued filming until the 21st.
Want to focus on that first day, June 20th. Did Mr. Jones complete the stunt on that first day?
Yeah, he did. He did it 6 different times, I think, and every single time Ms. Doig would give the signal after 4 seconds, he pulled the parachute and he landed completely safely.
So ma'am, after those 6 safe landings, did anyone ask to do another take?
Ms. Doig did. She said that she wanted to do one more the next day on the 21st.
Did Ms. Doig explain why she wanted to do another take?
She said she wanted more footage. She wanted a longer amount of time where he was in the air so she could get a better shot.
Said she wanted a longer amount of time when he was in the air. I want to be clear. How long did you see Ms. Doig wait from when he jumped off the ramp to when she sent that signal?
So on the 20th, when she did the stunt when he did the stunt 6 different times, Ms. Doig would always wait 4 seconds every single time.
Objection, Your Honor, lack of foundation. May I be heard?
Sure.
Your Honor, the witness hasn't laid any foundation at this point as to how she knew it was exactly 4 seconds every time. Was she watching a stopwatch? Was there a clock? Was there a different sort of timer? That foundation is important for the jury to hear.
Response?
Yes.
Your Honor, the witness has laid the foundation. She testified that she was in the control room with Ms. Doig when that signal was sent. That's enough foundation for her to testify about it. If Ms. Debnath wants to attack that on cross-examination, she's certainly able to. This is a matter of weight and not admissibility. We've laid the pertinent foundation.
May I be heard briefly, Your Honor?
Briefly, yes, go ahead.
A difference of seconds is very important to the matter in contention in this case. That's why it's important that the jury hears whether or not she was counting Mississippis in her head or if she was actually looking at a timer. That's why the foundation's important.
May I respond to that?
Yes, and last word.
Yes, Your Honor. Ms. Debnath can certainly ask how many Mississippis she was counting on cross-examination or about anything else she'd like on cross-examination about how she calculated that amount of time. At this point, we've laid adequate foundation that she was in the room, that she believed it to be 4 seconds. That's adequate for this witness to testify to that fact.
I think this is such a critical issue that you need some sort of foundation. And I don't think there's any, except
Yes, sir.
she was there.
Yes, Your Honor, we laid the foundation.
So I'm going to sustain the objection.
Ms. Gogan, you told us that you were in the control room with Ms. Doig. Is there a clock, a stopwatch, anything like that in there?
Yeah, there was a clock.
Okay, so between when Mr. Jones jumped off the ramp and when Ms. Doig sent that signal, how many seconds went by on that clock?
About 4 seconds.
Okay, and how many seconds did Ms. Doig say she was planning on waiting for that new stunt?
She said she wanted to wait 9 seconds, get an extra 5 seconds in the air.
You said that Ms. Doig had this new idea for the stunt. To your knowledge, was Ms. Doig the stunt coordinator on that film?
No, of course not. She was the producer. There was another stunt coordinator. I believe her name was Skye Stebbins.
Now, I want to be clear, was that other stunt coordinator, Skye Stebbins, did you see them there on the day you ran that new stunt?
No. On the 21st, I didn't see Miss Stebbins at all.
Okay, so I want to talk about that day, June 21st, day Mr. Jones died.
Okay.
Where were you that day?
I was in the control room watching the stunt on the footage.
Was anyone with you in the control room?
Miss Doig was.
Could you tell the jury how the stunt started that day?
It started just like it had the day before every single time. He got on the motorcycle, he rode off the ramp, jumped off the mountain, and got off the bike.
Now, ma'am, after he got off the bike, did Miss Doig send a signal after 9 seconds, like she said she would?
No, no, she didn't.
What about after 10 seconds?
No,
11?
no,
12?
she didn't say anything.
Did you ever hear her or see her give a signal to Mr. Jones?
No, not once. I was in the control room, I was waiting. Once it was 9 seconds, I started asking her, why aren't you giving the signal? And she just put her hand up like this to me. Didn't say anything. She was silent.
After you saw Mr. Jones hit the ground, what did you do?
Of course, we went out of the control room. We went to see if he was okay.
What did you see?
His body was on the floor. It was absolutely awful. He was dead.
Did Miss Doig say anything that day?
She said that she just wanted a longer shot.
After Miss Doig said she wanted a longer shot, did you say anything?
Of course, I asked her, why didn't you give the signal at 9 seconds?
Did Miss Doig say that
No.
she did give the signal?
No, she didn't.
Did Miss Doig say, well, maybe he didn't hear me?
No,
Did Miss Doig say maybe he ignored me for his reputation?
no, she didn't say anything.
What did Miss Doig say?
She didn't say anything at all.
Thank you, ma'am. Your Honor, I have no further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor.
Do you have enough room to get through over here?
You know what? I'll go that way.
All right.
I found a path.
All right. It's actually part of my physical fitness
Oh, yeah?
program here.
It's pretty effective. Good afternoon, Ms. Govian.
Good afternoon.
Ma'am, I want to start by saying that I'm sorry for your loss. If at any point you need a break or some water, you can let me know, and we'll make sure to get that for you, okay?
Thank you, I really appreciate that. I think I'll be fine.
All right. Ma'am, I want to pick up where you left off in your conversation with the plaintiff's counsel. You said that you never, not once, saw Ms. Doig give the signal, right?
She didn't.
Okay, well, let's talk about who was there to see whether or not Ms. Doig gave that signal. You were in the control center with Ms. Doig, right?
Yeah, I was.
But it was just you and her.
Yeah, I think she sent the rest of the staff home early.
So it was just you and her in that control center, so surely you don't know if the plaintiff's gonna call an eyewitness to say that Ms. Doig never gave that signal?
I mean, I'm saying that she didn't give the signal.
Anyone to corroborate what you're saying, ma'am? You have no idea if the plaintiff's gonna call someone?
You could ask Ms. Doig, she'll tell you.
We'll be sure to ask Ms. Doig on her direct examination about whether or not she gave that signal. In fact, Mr. Ryder, can you write that down? But ma'am, when it comes to what you know, it was just you and Ms. Doig.
Yes, that's right.
All right, so let's talk about your relationship to Mr. Jones, all right? Ma'am, it's true that Mr. Jones, he was a client of yours, right?
Yes, that's true.
But he wasn't just a client, he was also a friend, true?
Yeah, he was.
You'd say he was a good friend.
Absolutely.
You worked with him on every single one of his movies in his career.
I did, yeah.
Fair to say you spent a lot of time together, right?
Yeah, we definitely spent a lot of time together.
Let's go beyond that. That person who was your good friend, who you spent all that time with. He's gone now, right?
Yeah.
And sometimes in a tragedy like this, you might want to find someone to blame.
And I want Peter to have justice for what happened to him, absolutely.
I mean, you're saying you want Peter to have justice, but I want to be clear about this for the members of the jury. You're Peter's agent, right?
Yeah, I am.
So you knew that he made millions of dollars for the production company, the defendant in today's case.
Yeah, I think he did. He was a really big movie star.
Not just any movie star, he was a movie star for the production company Dragon Studios, right?
Yeah, he worked on, I think, 7 different all-lost films with them.
He didn't just work on those films, he was the star of those films for that production company, true?
Absolutely, yeah.
Okay, with that in mind, let's talk about how Mr. Jones might have felt about his reputation in that business. Ma'am, it's true that, well, Mr. Jones, he's no secret to stunts, right?
No, he does stunts in most of his movies. He's an action star.
That's right, he's an action star who always insists on doing his own stunts every time.
Yeah, he thinks it makes the scenes more authentic.
Some of those stunts, ma'am, he's rappelled down the tallest building in the world.
Yeah.
One time he was hanging off an airplane while it was taking off.
Yeah, he did.
Ma'am, Peter told you that he loved doing those stunts, right?
Yeah, that's why he kept doing it. I mean, he had more money than he needed, but he loved those movies and he loved doing those stunts.
In fact, he told you, I wrote this down to make sure I get it right. He said he loved the do anything for the audience reputation that he'd get from doing those stunts.
Yeah, absolutely. He wanted the audiences to like his movies.
So let's talk about how his love for that reputation might have affected him. Because it's true that as his agent, you're aware, Mr. Jones, he agreed to an original stunt plan where he would fall for 4 seconds, right?
Yes, that's true. That's the contract that we signed.
That's right, that's the contract that he signed, and you'd actually recognize that contract, right?
Yeah, of course.
I'm approaching opposing counsel with what's been marked as Exhibit 33. I'm approaching,
Looks good.
and I've got a copy for Your Honor, if I could approach.
Sure.
Now, Ms. Scopion, there's actually a witness binder in front of you. If you could flip to the 33rd tab, it should be marked in there. And let me know when you're there.
Sorry, there's a lot of tabs in here.
No worries, ma'am.
Oh, okay, I'm there.
So, we're seeing here, ma'am, that's the contract that Mr. Jones signed, true?
Yeah, this is his signature at the bottom, my signature, and Miss Doig's signature.
It looks fair and accurate to you?
Yeah, just like when we signed it.
Your Honor, the defense moves to enter Exhibit 33.
No objections to 33.
It'll be admitted.
Ma'am, taking a look at that contract, it says that Peter could have a risk of death from that stunt, right?
Yes, it says that he accepts the risks, including death, of the stunt in the stunt plan.
In the stunt plan, and that stunt in the stunt plan, you're aware that was a 4-second free fall, right?
Yeah, that's what we agreed to in the contract.
The thing is, ma'am, you were actually there when Peter decided to agree to not a 4-second fall, but a 9-second fall.
Yeah, I mean, he was reluctant at first, but Miss Doig told him that the stunt coordinator gave the green light, so.
Objection, Your Honor, non-responsive and speculative, may I be heard?
Yes.
Your Honor, the witness just responded he was hesitant at first, or reluctant at first. Your Honor, that is the witness stepping into the mindset of Mr. Jones, and it's inadmissible.
Response?
Yes.
Your Honor, counsel opened the door with this line of questioning. She said that she's going to be inquiring into how his reputation affected it and about his intent going into this contract and entering into this agreement. She's certainly allowed within the confines of that question to respond to her understanding of what Mr. Jones was doing when he was agreeing to that. The fact that he was reluctant isn't stepping into Mr. Jones' mindset. She can talk about the behaviors that he saw, and if Ms. Devika wants to clarify as to how she's reaching that opinion, she certainly can. That's a lay opinion she's able to make.
May I be heard, Your Honor?
Briefly, go ahead.
Yes, Your Honor. My question only asked about what Mr. Jones said. It didn't ask the witness to speculate into his mindset.
Well, the problem, I think, Mr. Marx, for the court is, I don't know any foundation. On its face, is there a possibility it's admissible? Maybe, but on its face, it sounds speculative to me.
Yes,
So,
sir.
objection sustained.
Motion to strike that part of the witness's answer.
That part of the answer at this point is stricken.
So, ma'am, you were actually at a dinner with Mr. Jones and the executive producer of the production company, right?
Yes, I was.
The two of you learned that, well, the stunt scene, it was too short, right?
That's what Miss Doig said, yeah.
So the executive producer, Miss Doig, she gave you both two options, right?
I'm not sure what you're talking about. She said that she wanted to extend the stunt to wait 9 seconds to pull the parachute instead of 4.
Okay, so let's walk through this step by step, ma'am. The first option she gave was right. You could extend the stunt and wait for 9 seconds instead of 4, true?
Yes, that's what she said she wanted to do.
The second option, well, she said we could edit together some footage, splice together the clips, to make it seem like the stunt was longer than it actually was, right?
Yeah, she said that.
And then she mentioned the press, true?
Yes, I think so.
She asked what Peter should do, what she should say, if the press asked how low he was willing to fall.
That's right.
And it was after Ms. Doy mentioned the press that Peter agreed to that stunt.
Yes, that's true.
And you tried to convince him no.
I did, yeah. I thought it wouldn't be safe.
But despite your attempt at persuading, he said no to you.
Yeah, he did.
Thank you for your time, Ms. Gouillon. Your Honor, I've got nothing further. You can set down the witness finder.
Any redirect?
Yes, Your Honor.
Go ahead.
Thank you. Ms. Gogan, you were just asked some questions about Mr. Jones's love of his reputation. I want to be clear. Was Mr. Jones the one who proposed this 9-second wait time?
No, he wasn't. It was Miss Doig.
You were also asked a lot of questions about what Mr. Jones agreed to. I want to make this very clear. Did you hear Mr. Jones agree to that 9-second time?
He agreed to the time after he was told the stunt coordinator said that it was okay.
Ma'am, when you were in that control room with Miss Doig, did she send the signal at 9 seconds like they agreed to?
No, she didn't. She never sent the signal.
Thank you, ma'am. Your Honor, I have no further questions.
Anything further? I do not recall if the rules allow recross.
No recross, Your Honor.
Very well. You may step down.
Thank you.
Plaintiff?
Plaintiff rest, Your Honor.
Very well. You may call your first witness.
Yes, Your Honor. The defense calls cold door. Moment of the court's indulgence is I.
No problem.
May I proceed?
Please.
Good afternoon. Can you introduce yourself to the members of the jury?
Good afternoon. My name is Cole Doy. I'm an executive producer at Dragon Studios.
You mentioned you're an executive producer. What does that job involve?
I direct and produce movies. The main franchise I work on is called the All Lost series. It's a franchise of action movies.
You mentioned the All Lost movies. Did you know Peter Jones?
I did. Peter Jones was the star of that franchise.
So, ma'am, given that you worked at the production company, would you be able to say that Mr. Jones was an asset to that company?
Absolutely. We couldn't make those movies without him.
With that in mind, ma'am, we've heard a lot today about how you failed to pull the signal at the right time to save Mr. Jones's life. I want to be clear with the members of the jury. Did you care for Mr. Jones's safety?
Of course I cared for his safety. I mean, he was the star of these movies, but Mr. Jones was also my friend. I would never have done anything to hurt him.
Did you ever intend for him to fall the way he did?
No.
So, ma'am, with that in mind, did you give the signal for him to pull his parachute on June 21st of 2023?
Yes, I gave the signal at 9 seconds, just like we'd agreed.
So let's go ahead and talk about that stunt itself, ma'am. What stunt was set to be executed on June 21st?
It was a stunt we've been working on for a while. Peter was supposed to drive a motorcycle off a cliff and then parachute down safely.
How did you prepare for that stunt?
We did 3 main things. We drew up a contract to make sure everyone was on the same page. We had a stunt plan so we knew exactly what we were going to do, and we provided him with all the safety equipment that he would need.
I want to zoom in on that contract and the stunt plan. Did you ever show those to Peter before he died?
Of course, he read and signed both of them.
So ma'am, in that binder that you have on the table right next to you, if you flip open, we'll be looking at exhibits 33 and 34. And I'm going to be approaching opposing counsel with what's already been admitted as exhibit 33 and what's been marked as exhibit 34. And Your Honor, I've got a copy of both exhibits 33 and 34. Would you like one?
No, thank you.
Of course. So ma'am, starting with exhibit 33, are you there with me?
Yes, I'm there.
Okay. Did Mr. Jones sign this contract?
He did.
When he signed it, does it say anything about the risks and types of injuries that might be associated with the stunt he agreed to?
Objection, Your Honor. We'd ask that before they go into the contents of Exhibit 34, that they enter it into evidence.
Your Honor, we haven't delved into the contents of exhibit 34. We're only talking about exhibit 33, which has already been admitted.
Okay, with that understanding,
Yes.
we'll withdraw.
Okay.
So ma'am, with me on exhibit 33 still?
Yes.
Okay, so what does it say about the risks of the stunt?
It says that the stunt was dangerous, that there was a risk of death, that Peter could get hurt.
Does it say at any point what other injuries he might endure?
It says that, I mean, he was driving a motorcycle off a cliff. It makes it clear that Peter could get hurt doing this.
Go ahead and flip to exhibit 34, ma'am. Do you recognize what that document is?
Yeah, this was the stunt plan that we made. This essentially laid out exactly how Peter was going to pull off the stunt.
Does it look the same as you last saw it?
Yes.
The defense moves to enter exhibit 34.
Any objection?
No objections to 34.
It'll be admitted.
So ma'am, taking a look at this stunt plan, was this referenced in exhibit 33, that contract?
Yeah, the contract says that Peter would agree to follow what was outlined in the stunt plan.
And when it comes to the outline of the stunt in this plan, how many seconds does it say Peter was supposed to fall before he received that parachute signal?
Peter was supposed to fall for 4 seconds.
Ma'am, you can go ahead and set that binder down for now. Now, we heard today that Mr. Jones, he didn't end up falling for 4 seconds on the 21st. He fell for 9. So, can you tell us what changed?
Yeah, so we practiced the stunt 6 times, and you know, I thought the scene should be a little bit longer, so I asked him, we had a conversation, and I asked if he'd be willing to fall for a bit longer, for 9 seconds, and Peter agreed.
Ma'am, I want to be upfront with the members of the jury. Did you ever push Peter into doing that more dangerous stunt?
No, of course not. I mean, I just proposed the idea. I asked if he'd be willing to do it, and Peter wanted to.
Ma'am, before you even proposed that idea to Peter, did you contact the stunt coordinator to see if it would be safe?
I did. I asked, and the stunt coordinator said that 9 seconds was doable, so that's what I told Peter.
Objection, hearsay.
Response?
Yes, Your Honor. This isn't hearsay because we're not using it for the truth of the matter asserted. We're using it for the effect on the listener, and that Ms. Doy would have learned from this information from the stunt coordinator that she thought it was safe.
Response to that?
Yes.
Your Honor, one of the issues in contention in this case is whether the decisions this witness and her company made followed the standard of care. Certainly testimony or hearsay statements from a stunt coordinator who is affirming the reasonableness of that plan is being used to prove the fact that that plan was reasonable. It certainly helps their case, and the jury is going to take inferences from that. Whether or not there's some tangential effect that it may have had on her, well, they can certainly talk about what she did without talking about the fact that this was proved. They're using this testimony to bolster the decision she made. They're using it to prove the truth of the matter asserted, and it's inadmissible.
May I be heard briefly, Your Honor?
Yes.
I understand Mr. Marx's concern. We'd be happy with a limiting instruction to the jury instructing that the statement isn't to be taken for its truth. We're only using it for the subsequent action of this witness.
Response to that?
Just to that, yes.
Your Honor, we don't believe a limiting instruction would be sufficient here. The reason why is because there's no subsequent action that's going to happen after her getting it. The subsequent action she's going to get is that she felt affirmed in her decision to do this because someone said it is reasonable. To the extent there's any effect on the listener, it's that her conclusion is being affirmed by an expert. They're using that statement to prove the truth of the matter asserted, and the jury's certainly going to take it for that.
Okay. I tend to not completely go along with the semantics you're using subsequent act. However, I do think a limiting instruction is appropriate. So I will pretty much, because, and the reason I'm saying the subsequent act, I think the effect on the listener is the issue. That's because her mindset is huge to this case, as I understand. So I'm just instructing the members of the jury to completely disregard the taking any truth to that particular comment. You are completely disregard the use of that as truth. Only as to the effect, if any, it had on this particular witness. So with that, go ahead.
Yes, Your Honor.
Thank you for both of you for your arguments.
Yes, Your Honor. So we were just talking about, ma'am, how you spoke to the stunt coordinator. After the stunt coordinator said the stunt was doable, what did you do?
I checked the calculations and I made sure that it would be doable, so I told Peter that we could do 9 seconds, and Peter agreed.
Ma'am, I want to be clear. If Mr. Jones had said no to that revised stunt, would it have happened?
Of course not, no.
Let's talk about what happened on June 21st then. Ma'am, how did that day start?
We were gonna practice this stunt one more time. So I was in the control room and Peter was on the motorcycle, he was doing the stunt, and I was gonna be the one to give him the signal at 9 seconds.
Did you give him the signal at 9 seconds?
Yes, exactly at 9 seconds, I told him to pull the parachute.
Did Mr. Jones pull the parachute?
No.
So what did you do?
I said, you have to deploy, pull the parachute.
Did he?
No. I don't know what he was thinking, but he did it.
And what happened to Mr. Jones?
I watched him falling. He didn't pull the parachute in time, and he died.
Thank you for your time. Your Honor, I've got nothing further.
Cross-examination, Mr. Marks?
Yes, Your Honor. May I proceed?
Please.
Thank you. Good afternoon, Ms. Doyle.
Good afternoon.
I want to start by making something pretty clear right off the bat. You're certainly not an expert in skydiving, are you?
No, we had a stunt coordinator for that.
That's right. As a producer, it's your job to hire experts like stunt coordinators, right?
Yes.
Because one of the things that does fall within your responsibility is keeping your cast and crew safe.
Yes, of course.
So you hire those experts to confirm that those stunts are going to be safe for them to perform.
Yes.
Like you told us that's what you did in this case, right?
That's what I did, like I always do. I made sure it was safe.
Right, you had that stunt coordinator make this plan, Exhibit 34.
Yes.
And on June 20th, the day before Mr. Jones died, well, you followed this plan, right?
That's right. We practiced this stunt like that plan out.
Right, Mr. Jones, he'd been practicing this plan for months.
That's right.
This plan was made over a year before shooting started.
Yes.
And when you followed this plan, well, Mr. Jones, he landed safely.
Of course, nothing happened until the 21st.
Man, we'll get there in a moment. You'd agree. When you followed the plan, he landed safely.
Yeah, it went right every time except the 21st.
Let's talk then about what was different on the 21st. Because on that day, you decided not to follow that plan, didn't you?
Peter and I agreed to push it to 9 seconds.
That's right, ma'am. You decided to disregard the plan that your stunt coordinators made.
Peter and I both agreed to 9 seconds. It's different than the stunt plan, but yes.
And we'll talk about what Peter and you actually agreed to, but you would agree with me that you proposed doing something different than that plan, correct?
Yes.
You said that you wanted to make Mr. Jones wait longer as he was falling in the air.
I wanted the scene to be longer. When Peter and I talked about it, we agreed that we would wait until 9 seconds, that he would be in the air for longer, yes.
That's right, he would be in the air 2 times longer, right?
A little over that, yes.
2 times longer than the plan your experts made said he should be.
Yes, but I checked with the stunt coordinator, and they said 9 seconds was doable.
Ma'am, I know you're saying that you checked with the stunt coordinator, but you'd agree that in this document here, Exhibit 34, the safety plan, it says the industry standard is that the parachute should be deployed at 2,000 feet in the air, correct?
That's my understanding, yes.
It was your understanding that if you had Mr. Jones wait for 9 seconds, he wouldn't deploy his parachute until 1,000 feet.
That's true, but 1,000 feet was doable. It could still be done safely.
Ma'am, you're saying it's doable. Be clear, you're not a safety skydiving expert, are you?
No, it was the safety coordinator that told me that.
Well, ma'am, what the safety coordinator said in this document is that the industry standard is 2,000 feet, correct?
Yes.
You decided to go against the industry standard.
Yes.
You proposed to go against the industry standard.
I did, but only after checking.
Now, ma'am, you told us earlier that you and Peter, you entered into this agreement about what the stunt was going to look like on June 21st. Do you remember saying that?
Yeah, Peter and I agreed.
Ma'am, I want to be very clear for the members of the jury about what Mr. Jones actually agreed to. Because, to be clear, you agreed that you would watch the altitude Mr. Jones was at in the air that day, right?
Yes.
You had a tracking device on him and on the bike, right?
Yes.
You agreed that you would tell him when he needed to deploy his parachute.
I would send the signal at 9 seconds.
That's right, you agreed that you would send that signal at a specific time.
Yes.
That was the agreement that you and Mr. Jones entered into before he ever got on that ramp that day, correct?
Yes.
You violated that agreement, didn't you?
No. I send the signal at 9 seconds.
Oh, ma'am, you were here when Ms. Goguen testified today, weren't you?
Yes, I heard what she said.
You heard Ms. Goguen said that you did send the signal at 9 seconds.
I sent that signal. She was there. I don't know why she would say that, but I sent the signal at 9 seconds.
Ma'am, I understand you're saying that, but right now I'm going to need an answer to my question. You heard Ms. Goguen say that you did not send that signal.
I heard her say that, yes.
And are you telling us that she's lying to the members of the jury?
I don't know why she would say that. I don't know that she was lying, but I sent the signal at 9 seconds. That's all I can tell you.
Ma'am, you certainly can't think of a reason why Ms. Goguen would lie here today.
Sir, I don't know what Miss Goguen is thinking. All I can tell you is that I sent it at 9 seconds. I did.
Ma'am, I want to talk a little bit more about what you said about sending it at 9 seconds in the past. Because you'd agree with me, we spoke before trial, didn't we?
Yes.
We sat down, we had something called a deposition.
Yes, that's right.
In that deposition, we asked you about when you were down with the body, right?
Yes.
Now, there were crew members around, right?
Yeah, me and the crew members, after the stunt went wrong, we went to go see Peter's body.
And in front of the crew members, you said, I wanted a longer shot. I thought we had enough time.
I did. I wanted a longer shot, and I thought 9 seconds was enough. I don't know what happened.
Well, man, the first time we asked you about that in your deposition, that wasn't the answer you gave, was it?
To be honest, seeing Peter's body there, I didn't really know what to say.
Well, ma'am, to be clear, when we asked you what you said by the body with the crew around, you said that you didn't remember.
Yes.
That was a lie, wasn't it?
No.
Well, ma'am, you would agree you said you didn't remember what happened there, right?
And me and my crew members went to go see Peter's body. I didn't remember what I had said when I was looking at his body, but now I remember I said that I wanted a longer shot, and then I didn't say anything else. That's all that happened.
You'd agree you said you didn't remember, right?
Initially, yes.
Then we said that we could go ask the crew members who were there what you said.
Objection, Your Honor, hearsay. May I be
Respond.
heard?
To this last question?
Yes, Your Honor, if I could explain.
Sure.
Yes, Your Honor, Mr. Marx is eliciting statements from his own counsel in a prior deposition. Those statements from his own team of attorneys that they could depose the crew members if they wanted to, that's an out-of-court statement now being used for the truth of the matter asserted. It's hearsay.
Response?
Can you confine it to why are you offering that?
Yes, Your Honor. We aren't offering it to prove the truth of the matter asserted. Instead, what we're using it for is the effect on this listener. Specifically, that after that question was asked, she changed her answer. It's going solely to the effect, and we're fine with the limiting instruction for the jury to take it as such.
I'm going to overrule the objection. I'll give a limiting instruction to consider it only for purposes of the effect on the listener.
Yes, Your Honor. We said that we could go talk to the other crew members who were there, right?
Yes.
And then you changed your story.
I didn't change my story. I remembered what I said.
Right. After we said we could go talk to other people about what you said, then you remember what you had said that day.
Yes, that happened before.
I want to be very clear about what you did and didn't say that day. Because while you were at the scene, Ms. Goguen, she asked you, why didn't you send the signal at 9 seconds?
She asked that.
You didn't say, what are you talking about? I did send the signal, did you?
No.
You didn't say, well, Mr. Jones, he must not have heard me, the earpiece must have malfunctioned.
No, I wasn't proposing other options, no.
When she said, why didn't you wait for the 9-second mark and send the signal, you said nothing, didn't you?
I gave him the signal at 9 seconds. I didn't have anything to say to that.
Not asking when
That's
you're...
time.
No further questions.
Okay. Is there any redirect?
No redirect, Your Honor. My witness be excused.
You may step in. Thank you. Anything further from the defense?
No, Your Honor, the defense rests our case and we're ready to move into closing arguments.
Okay.
Yes, Your Honor?
You ready, Mr. Marks? Go ahead.
Thank you. there are some things that everyone in this courtroom can agree on. Everyone agrees that before that stunt was ran, the defendant hired an expert to make a safety plan. Everyone agrees the defendant didn't follow that safety plan on June 21st. And everyone agrees the first time the defendant decided not to follow that plan, Mr. Jones died. So where we disagree, and what this case really comes down to, is whether that choice, the choice not to follow the safety plan made by their expert, caused Mr. Jones' death, or whether he accepted the risks to further his own reputation. Now today we've proven that the defendant is liable for negligence. Now, as the judge will tell you, the elements of that claim are pretty straightforward. We had to prove that the defendant breached their duty of care to Mr. Jones, and that Mr. Jones died as a result of their failure to follow their obligation. But you also heard today that the defense has a burden as well. Because they chose to bring an affirmative defense, saying that Mr. Jones assumed the risk, well, they have to prove that it was more likely than not that Mr. Jones understood the risks, understood the gravity of those risks, and died as a result, or still decided to do the stunt. But they're not going to be able to meet that burden today. They haven't met that burden today. And to help you see that, I want to go back to those same three facts we asked you to keep in mind at the beginning of this trial. So first, the stunt. You heard today that Mr. Jones had practiced this stunt countless times before. You heard that they made a safety plan. Now today they tried to tell you that this safety plan that they made, this contract they entered into, well, it was this agreement that showed that they cared about Mr. Jones. They asked, well, Mr. Jones was an asset to your company, you'd certainly want to keep him safe, and you'd done it safely before. To try to prove to you today that she actually sent the signal on the day she died. They said over and over and over again, well, she'd done it before, she followed the plan. But here's the problem. The moment they strayed from that plan is the moment Mr. Jones died. Which brings us to that second thing, the signal. Today you heard that Mr. Jones didn't deploy his parachute until he was seconds away from the ground. Not at 4 seconds, like the experts recommended, not at 9 seconds, like they claimed they wanted to. Too late. Now today they tried to tell you that Ms. Jones, or Ms. Doig actually, well, she did send a signal that day. But here's the problem. You heard from Ms. Gogian, a witness with no reason to lie, a witness with no reason to misrepresent, a witness with no dog in this fight, who told you that she was in the control room, that she saw Ms. Doig, and that Ms. Doig never sent that signal. Now today they want you to believe maybe Ms. Gogian was mistaken, maybe Ms. Gogian made it up. But have you actually heard any evidence that supports that? I mean, it's not like Ms. Gogian is misremembering what color shirt she has. She has a very specific memory of what happened that day. She remembers that she didn't send a signal. She remembers yelling at her to get her to send a signal. She remembers her telling her that she wasn't going to. And so you have to compare whether or not the story Ms. Gogian and Ms. Doig are telling you, which one is more likely than not. And you know that the defendant has changed her story about what happened that day. You heard that the first time we asked her about what she said on that day, she claimed that she didn't remember at all. But then when she learned that maybe we were going to try and corroborate that story, see if what she was saying was true, then suddenly she fesses up and says what happened. And that's how you know that what the defendant is telling you just isn't true. It's how you know that she didn't send that signal. And that brings us to that third and final thing, the silence. Now today they tried to tell you that Mr. Jones, well, he accepted the risks. He knew the risks. He assumed the risks. But here's the problem. The agreement they entered into that day, it was that she would call for the signal at 9 seconds. And the evidence shows that she didn't do that. And so because of that, he wasn't able to assume the risks for what would have happened here. He wasn't able to assume the risks because they violated their agreement. She didn't do what she said she was going to. When Mr. Jones was in the air, the defendant stayed silent. When he went up that ramp, the defendant stayed silent. As he was falling down, the defendant stayed silent. And it's those choices, the choice to disregard the risks, the choice to be a daredevil in the face of danger, the choice to be flippant in light of Mr. Jones falling out of the sky, those are the choices that show that this defendant is the producer who pushed too far. And at the end of the day, that's what makes this case so unfortunate. Because at every point on June 21st, the defendant was the one calling the shots. They had the option to send that signal. They had the option to stop all of this, to make sure that Mr. Jones got back safely. But she didn't. The defendant pushed Mr. Jones to change from that safety plan, pushed Mr. Jones to wait longer that day, pushed Mr. Jones to his death. That's why we ask that you find the defendant liable. Thank you.
Thank you, Mr. Marx. Ms. Debnath?
Yes, Your Honor. Before I proceed with closing arguments, could I hand the jury a copy of the verdict form they'll be filling out when they go to deliberate?
Sure.
And Mr. Marx, if you'd like to take a look at this as well. I think I'll squeeze past it, there's no safe here.
Okay.
Apologies. May I proceed, Your Honor?
Yes.
He took the risk to protect his reputation. Members of the jury, in the time that I have with you, I want to cut straight to the chase. You've got a verdict form in front of you. Let's go through it together. Because when you go to deliberate, this is exactly the form that you'll have to fill out, and it's got 2 questions on it. First, did the plaintiff prove that the defendant's negligence was a cause of Peter Jones's death? Yes or no? I want to be clear here, members of the jury. If the answer to that question is no, we're done here. I can sit down right now and we can all go home. But if you think that Dragon Studios had any negligence in any part, if you believe any part of the plaintiff's story, then we want to cover all of our bases. We've got a second question here for you too. Another hurdle that the plaintiff has to jump over, just like I mentioned in opening statements. Did the defendant prove that Peter Jones assumed the risk that caused his death? So members of the jury, let's go through these 2 questions one by one. Starting with this first question. Did the plaintiff prove that the defendant's negligence was the cause of Mr. Jones's death? And all that means is that it comes down to whether or not that call was made. Now, Mr. Marx is right. That call is important to this case. I mean, we spent a lot of time talking about it. But that call, it quite literally comes down to a he said, she said. Members of the jury, we heard testimony from Ms. Gogion. And I asked her about who was inside that command center when Mr. Jones was falling. She said it was just her and Miss Dorn. So if we got only those 2 witnesses, we got to ask ourselves, who can we trust? Well, Members of the jury, Ms. Goulion, she said something interesting during my conversation with her when I asked her if she knew if the plaintiff would be calling another eyewitness to testify as to whether or not Ms. Doy actually gave the signal. She said, well, I don't know. They asked Ms. Doy. We did. Ms. Doy did give that signal. And doesn't it make sense that she would, members of the jury? Because we've been hearing all trial how invaluable Peter Jones was to that production company. He meant everything to them. He was part of their blockbuster hit franchise, All Loss, making not 6 movies, but 7 movies. That was their goal. Without him, we heard today that franchise would fall apart. Why would they be so careless with his life? Does that make sense to you? Mr. Marx is saying, oh, we got no reason not to trust Ms. Goulion. Is that what we heard today? Because when I asked her, what are you here for? She said to find justice for Peter. When I asked her, sometimes in a tragedy like this, we look for someone to blame, she said, I'm just trying to find justice for Peter. Members of the jury, we understand why she's angry. She lost a friend to a horrible accident. But it's like we said at the beginning of this trial. We can't let our emotions guide our judgment. The evidence does that for us. All right, that second question on your verdict form. Did the defendant prove that Peter Jones assumed the risk of death? Now that's on us. We had a burden to prove to you, more likely than not, that Mr. Jones did assume the risk of death. Now, I want to think about this clearly, because I don't think it takes any kind of rocket scientist to know that if you're motorcycling off a cliff with a 2,000-foot drop, that's dangerous. But beyond that, we've actually got it in writing that Mr. Jones agreed to that stunt plan. Members of the jury, you're going to have a chance to take a look at this contract and this stunt plan. You're going to find that Mr. Jones agreed that there was a risk of death for a 4-second fall. So, of course, when at that dinner he agreed to the 9-second fall, he knew there was a risk of death associated with that too. I mean, what does the plaintiff want to believe? That Mr. Jones thought he would sprout wings and fly away after that 9 seconds? No. This is where you get to use your common sense, members of the jury, because you don't leave that at the door. Mr. Jones knew about the risks. And why did he take those risks? For that reputation that we heard about. He took the risk to save his reputation. Members of the jury, sometimes things are so risky that you can't blame anyone else for what happens, and that's what happened in this case. So I'm going to ask that you find Dragon Studios not liable. Thank you for your time.
Thank you, counsel. Debnath?
Yes, Your Honor. Defense counsel just made a big deal out of the fact that Ms. Goulion agreed that in a tragedy, you look for someone to blame. Right, she was in the control room looking right at her when she failed to give that signal. I mean, think of all the things that would have to be true in order for Ms. Doy to be telling the truth. You would have to believe that Ms. Goulion invented this entire elaborate story under oath and lied to you. You would have to think that Mr. Jones, who followed the signal that came from her on the other 6 times, just randomly decided not to that day. You'd have to believe that maybe the earpiece that worked every single day stopped working. It's not more likely than not. Find her liable. Thank you.
All right. Well done. This Scoring system typically goes relatively quickly, so if you just give us a few minutes. Actually, probably 2 minutes.
No worries, Your Honor.
1 minute for everybody else and 2 for me.
Do you mind if we take a second to clean up while we're waiting?
Oh, sure. I mean, you can stand up and talk, but please don't, unless you really have to use a restroom, please don't leave so you guys can get ready for your next round.
Yes, Your Honor.